Okay, so we're back now for part 2 of chapter 8, talking about police and the rule of law. And we had left off talking about stop and frisk. So let's go ahead and jump right in. So, one important exception to the rule requiring a search warrant um, and even probable cause, actually, is the stop and frisk procedure. And this type of search typically occurs when a police officer encounters a suspicious person on the street and as a result ends up frisking or patting down that person's outer clothing, if you will, to determine whether that person is in possession of some type of weapon. And the police officer need not, again, have probable cause to arrest the person at that time, but simply must be, have reasonable suspicion based on the circumstances of the case. So that is the time and place, their experience as an officer, etc. So the stop and frisk search basically consists of two distinct components. First would be the stop, in which a police officer wishes to briefly detain a suspicious person in an effort to affect crime prevention and detection. And then second, to frisk, in which the officer pats down or frisks a person who is stopped in order to check for weapons. And the purpose of the frisk is to protect the officer making the stop. So Terry versus Ohio was in fact the first case in which the Supreme Court approved a search, basically, and seizure of a person in a criminal case under the Fourth Amendment based on reasonable suspicion. And the reasonable suspicion standard was derived from balancing the need for swift action by an officer to investigate, detect, or prevent crime against the modest intrusion, if you will, of an individual's privacy. So hopefully that kind of makes sense to everybody. And this is actually, it happens across the United States, and some people view this as a good thing and others do not. So, what kind of behavior can trigger a Terry search, if you will? Well, how a suspicious person, how do they have to look before police can legally stop them and pat them down? Well, there was a case, Illinois versus Wardlow, in 2000, where the defendant was walking on the street in an area known for narcotics trafficking. And when that person made eye contact with a police officer riding in a marked police car, he then ran. So the officer ended up catching up with the defendant on the street, stopped him, and conducted a protective pat-down search for weapons. And through this search, a handgun was discovered, in that person's possession. And that person was also, a felon. So the Illinois Supreme Court ruled that the frisk, in this particular case, violated the Terry versus Ohio case because flight may simply be an exercise of the right to go one's way and did not constitute reasonable suspicion. However, on appeal, the U.S. Supreme Court reversed the state court, ruling that a person's presence in that high crime area in and of itself is not enough to support reasonable suspicion, by itself, right? It held that a location's characteristics are sufficiently suspicious to warrant further investigation, and the additional, factor here of the defendant's unprovoked flight, meaning that he ran, added to that reasonable suspicion. Therefore, this case was actually upheld. So, again, this is how the Supreme Court will look at these things in kind of the totality of circumstances. So now we're going to kind of move on and talk about searches incident to a lawful arrest. So when you're talking about search incident to a lawful arrest, it needs to be conducted at the time or immediately following the arrest. So basically, a police officer may search the person and also the immediate area of control for weapons, contraband, evidence, etc. So, here, the police officer who searches a suspect incident to a lawful arrest must generally observe two rules. One, the search needs to be conducted at the time or immediately following the arrest. And two, the fact that the police may search only the suspect and the area within that person's immediate control. So the search basically may not go legally beyond that area where the person can reach for weapons or destroy evidence, etc. Otherwise, you're going to need a warrant. And this is based on the case Schimmel versus California in 1969. And here, the U.S. Supreme Court defined the permissible scope of a search incident to a lawful arrest or because of a lawful arrest. Okay, the police can search a suspect without a warrant after a lawful arrest to protect themselves from danger and secure evidence. Okay, but a search of a person's home is a little bit different. So you're allowed to, whether it's a vehicle or actually even a person's home, that you can search within arm's reach, basically, is kind of how this Schimmel case comes about. So just kind of an example by way of picture, and I don't know if I have a better one. Okay, here we go. So if this person was arrested in their home, anything within that arm's reach could be searched without a warrant. So the couch that the person was sitting on, the person, the nightstand or the little dresser right here, and the table for contraband or weapons. Now, anything further you can't do. Now, there are some cases where you can do a protective sweep, if you will, for suspects hiding, etc. But we're talking about a general search incident to a lawful arrest. So hopefully this picture kind of helps you, because here they could hide a weapon in the, let's say, the crack of the couch or under the couch or on the table or in one of the drawers. So that's the rationale for that within arm's reach type thing. Other things to kind of consider is when you're talking about search warrants, and we talked about this before, okay, that when you're, if you're looking for smaller items of contraband that are listed in the warrant, etc., you can search in small places, but if it's a larger item, you may not be able to search. And hopefully that kind of makes sense, right? So this is just kind of a picture to show you that, look, if you're looking for, let's say, a bunch of rifles that were stolen, okay? Well, depending upon how big they are, you may not be able to find one in here or in this little basket, but you could find one in a larger cabinet or, in a safe or something, or let's say in a larger container. So it really depends upon the size. Okay, vehicles can be searched without a warrant as long as there is probable cause to search. So the U.S. Supreme Court, Carroll versus United States, established that certain situations justify the warrantless search of a vehicle on a public street or highway. So evidence, can be seized from a vehicle when a suspect is taken into custody in a lawful arrest. So in Carroll versus U.S., which was decided back in 1925, the Supreme Court ruled that distinctions should be made among searches of vehicles, persons and homes. And the court concluded that a warrantless search of a vehicle is valid if the police have probable cause to believe that that vehicle contains the evidence that they are seeking. Okay, so and basically also, because of vehicles, and they call this the automobile exception, because of their mobility, a lot of times it's not practical to require the police to get a search warrant for a vehicle due to their mobility. So again, This Carroll versus United States is one of those cases that gives law enforcement a little bit of additional flexibility. So, let's kind of look a little bit further. Let's go into this just a little bit further. So when you talk about, because police are now confronting significant social problems as drug trafficking, terrorist activity, etc., the Supreme Court has given them some additional kind of leeway in terms of making stops. So, in a couple of cases, in 2002, the case of United States versus Arvisu, the court allowed a stop and eventual search of a vehicle based on a pattern of suspicious behavior. Okay, so kind of interesting. So here, when you talk about that, a vehicle registration check shows that the vehicle was registered to an address in a area notorious for narcotic smuggling. The patrol officer's personal experience and his knowledge that the suspect had taken a route frequently used by drug smugglers. The driver's route having been designed to pass through an area during a border patrol shift change. So these are all cases that kind of are, focused around that U.S. versus Arvisu, that, probable cause can come to light through different circumstances, right? So although each fact alone was not sufficient to justify the search, etc., together they supported the officer's decision to stop the vehicle and subsequently search it. So just kind of finishing out, a container inside of a vehicle may be searched without a warrant if there is probable cause to believe that the container has the object of the search. Okay, and remember, probable cause, there's a lot there. Probable cause limited to the container, meaning you can search only the container but nothing else, because you're thinking that whatever you want that you believe is illegal is in the container. And probable cause extends to the vehicle. You may search the entire vehicle and open containers. So again, there's a lot to say when it comes to cars, and there's a lot of moving parts sometimes, if you will. There's also something called a pretext stop. And this, again, is kind of a controversial type thing. So a pretext stop is one in which a police officer can stop a car because they suspect the driver is involved in a crime such as drug trafficking, but they lack probable cause. So instead, they use a pretext like a minor traffic violation for the stop of the car. So this is the Wren versus United States case in 1996. So basically here, in this particular case, two defendants claimed that plainclothes officers used relatively minor traffic violations as an excuse or a pretext to stop their car because the officers had basically lacked objective evidence that they were drug couriers. Now, the Supreme Court in this case basically ruled that if probable cause exists to stop a person for a traffic violation, and actually you only need reasonable suspicion to stop a car for a traffic violation, then that actual motivation of the officers is irrelevant. Therefore, the search is legal. So if they observe a traffic violation, they can stop the vehicle, and then during that stop, if they develop probable cause to search, then that will be sufficient. So the reason that you stop the car doesn't matter. It just needs to be lawful, which would be lawful, a traffic violation. And hopefully that kind of makes sense. So that's a pretext stop, all right? What about roadblocks or, searches related to roadblocks? So, sobriety checkpoints are lawful, serving the broad social benefit of protecting motorists from drunk drivers. These are another form of a stop, and they've been declared constitutional. Border checkpoints, because they have a broad social purpose, have also been declared constitutional. Now, again, to search, you're still going to need that probable cause, but to stop, having a sobriety checkpoint is fine to stop and determine if you're under the influence, etc. And the same with border checkpoints. Those are constitutional. Consent searches. These are, police officers may undertake a warrantless search when the person, in control of the area or the object, whatever that is, consents. And that makes sense, right? They ask you and you consent. Now, those who consent to a search essentially waive their constitutional rights under the Fourth Amendment. And ordinarily, the courts are reluctant to accept such waivers and require the state to prove that the consent was voluntarily given. So this really is the key. So in addition, the consent must be given intelligently, and in some jurisdiction, consent searches are valid only after the person is informed of the option to refuse consent. Now, in most jurisdictions, that is not true. You don't have to tell someone they have the right to refuse, but you do have to make sure that their consent is voluntary. So with that being said, the key to creating a voluntary contact is to ask for or request cooperation in a manner that suggests an option, or simply to strike up a normal, non-coercive conversation. So here, your exact words are extremely critical. So there really is nothing wrong with an officer on a valid stop asking if they can search an area, because you can say no, right? Okay. So what about third-party consents? So, it is okay for co-occupants, if you will, to give consent if that third-party person shares common authority over that particular property or area, and no present co-tenant is there to object. Bus sweeps. Today searches have an additional significance because of their use in drug control programs. So, an investigative technique in which officers board a bus or train without suspicion of illegal activity, seeking permission to search people's luggage. So are these okay? Well, on June 20th, 1991, the U.S. Supreme Court in Florida versus Bostic upheld the drug interdiction technique known as the bus sweep, where police officers board buses and, without suspicion of illegal activity, question passengers, ask for ID, and request permission to search luggage. So now, again, these are kind of controversial. Here, the Supreme Court was faced with deciding whether consent was freely given, or the nature of the bus sweep basically negated the defendant's consent. And the court concluded that the drug enforcement officers, after obtaining consent, may search luggage on a crowded bus without meeting the Fourth Amendment requirement for a search warrant or probable cause. But these can be a little bit tricky. And then you have the free to go thing. So what if a police officer stops a motorist and asks for consent to search the vehicle? Must the officer, again, inform the driver that he or she is free to go before asking for consent to search the car? And the short answer here is no, they don't have to. Plain view. This basically is where the Supreme Court has also ruled that police can search for and seize evidence without the benefit of a warrant if it is in plain view. So the plain view doctrine is the principle that evidence in plain view of police officers may be seized without a search warrant. Okay, so if an officer is then engaged in a lawful search and has probable cause that an item in plain view is subject to seizure, meaning that it's contraband, the item can be seized. But there's one other little thing here. The officer must be legally at the location and recognize the item to be contraband. So remember I told you that if they're serving a search warrant for, let's say, heroin, and they're at this residence and they're searching, but as they're going through, they view several marijuana plants. Could they seize those? The answer would be yes, because they are legally at that location and they recognize the item to be contraband. So that's part of the plain view doctrine. Okay, so a while ago we talked a little bit about if a person commits a crime in an officer's presence, then no warrant is necessary before an arrest is made, right? But what about this type of scenario? And I'm not trying to fool anybody, but let's say that you get a call of a traffic accident, a single vehicle that hits a tree. And you get there, and this is the picture that you see. Single vehicle accident, vehicle versus tree. There's nobody there. The motor's still running on the car. There's fluid leaking. So this just happened. And when you look inside the car, you see an open beer and you smell alcohol. And there's no one there. And then you decide, well, and you look at the windshield and there's a big, it looks like somebody may have hit their head on the window. And so you figure, okay, there must have been a driver here a minute ago. So you drive down the street about a block, and about a block away from here is an individual sitting on the curb. He's got blood on his forehead, and he appears to be under the influence of alcohol. And you obtain identification from the person, and you run that individual through the system, and it comes back that he owns this type of car. Can you arrest him? What do you think about that? I'm going to let you stew on that one. And if you want to make a comment, you can. Okay, so think about it. Now on page 315, it talks about, again, all those warrantless searches that we talked about. The emergency circumstance, the stop and frisk, the search incident to arrest, the car search or automobile search, consent, plain view, and then a crime committed in the officer's presence. So, and if that happens, then of course you can search incident to an arrest. But what about the DUI scenario that I gave you? All right, think about it. Okay, so we're going to finish up talking about a couple of other things. Electronic surveillance, the use of wiretapping to intercept conversations between parties has significantly affected police investigative procedures. Electronic devices enable people to listen and to record private conversations of other people over telephones, through walls and windows, and even over long-distance phone lines. Now, using these devices, police are able to intercept communication secretly and obtain information related to criminal activity. Now, the oldest and most widely used form of electronic surveillance is what we call wiretapping. And with approval from the court and a search warrant, okay, law enforcement officers place listening devices on the telephones to overhear oral communication of suspects, and such devices are also often placed in homes and in vehicles, and through a warrant, the evidence collected is admissible and can be used at a individual's trial. Now, in response to concerns about invasions of privacy, the U.S. Supreme Court has increasingly limited the use of electronic eavesdropping, if you will, in the criminal justice system. And in this case, we're looking at here, Katz versus United States. The court ruled that when federal agents eavesdrop on a phone conversation using a listening device that could penetrate the walls of a phone booth, that they had actually conducted an illegal search and seizure. So the Katz doctrine is usually interpreted to mean that the government must obtain a court order or a warrant if it wishes to listen on a conversation in which the parties have a reasonable expectation of privacy. So while some of you are very young and maybe you don't know what a phone booth is, but in the olden days, they actually had doors And that was the expectation of privacy. When you close those doors on a phone booth, the thought is that you have some privacy there. Now, if you're in a restaurant talking and somebody overhears you, well, that's different, right? There's no right to privacy. So thus the basis for the Katz case. And then some other important federal legislation governing the, kind of the interception of communication includes wiretaps, again, the Patriot Act, and even the Foreign Surveillance Act. So we talk about FISA. So it can be, relatively painless to secure a warrant for an ordinary search. But the police have to jump through many more hoops when it comes to electronic surveillance. Okay, so there are some things. Now, the Patriot Act, the controversial, if you will, kind of legislation enacted after 9/11, expanded the number of criminal statutes for which wiretaps can be authorized. All right. And the Foreign Intelligence Surveillance Act, FISA, is the organization that authorizes wiretapping of, any alien the government believes, and we're talking about somebody not a citizen of the United States, if you will, is a member of a foreign terrorist group or is an agent of a foreign power. Now, in the case of U.S. citizens, there must be probable cause that the person targeted for that wiretap is involved in criminal activity, and there is no such requirement for someone that is not a citizen. And FISA warrants are authorized by the secret, kind of that secret foreign intelligence surveillance court. It's the FISA court, which meets in a heavily secured room within the U.S. Justice Department. And this court is staffed by 11 judges appointed by the Chief Justice of the U.S. Supreme Court, and they each serve basically 7-year terms on the FISA court. And just as the Patriot Act altered the Federal Wiretap Act, it also altered FISA. It did so by allowing prosecutors to gather evidence in cases involving national security type crimes. In 2007, President Bush signed into law that controversial, Protect America Act, and it removed the warrant requirement for surveillance of foreign intelligence targets that the government reasonably believes are operating outside of the United States. So there's just a lot there when you're talking about federal legislation governing the interception of communication. So something that's kind of a little more close to home as far as what law enforcement, your average law enforcement officers might talk about, would be surveillance cameras or GPS. Now, many large cities, of course, right, have installed in public locations security cameras that can be monitored by officers from a distance. And since they were, used as investigative tools, so that the officers could go back through the recorded video and find evidence of crimes committed in the camera's view. That's really what they're for. And, they were eventually monitored on a regular basis. The cameras have proved helpful in more than one occasion, but cities claim sometimes that these prying eyes, if you will, violate people's privacy. Now, here's the bottom line on surveillance cameras. If they are put up in a public place, even if it's a park, you don't need any type of warrant. The local law enforcement agency, the federal law enforcement agency can put up a camera anywhere in a public place where there is no right to privacy. Now, GPS is a little bit different, okay? So in the United States versus Jones case, the Supreme Court decided on the constitutionality of GPS tracking of criminal suspects. So without a warrant, in this case, police installed a tracking device on Antone Jones' vehicle and tracked his movements for about a month. And they were able to use the evidence obtained from the tracking device to successfully build a drug trafficking case against Jones, who was ultimately sentenced to life in prison. Now, interestingly, the Supreme Court sided with Jones and reversed his conviction, concluding that the use of the GPS tracking device constituted a search and therefore needed to be supported by probable cause and a warrant. So GPS is a little bit different. All right, makes sense? Now, if somebody has one of those iPhones where you can track their phone and they have it turned on, that's different. But if you're going to put a tracker on somebody's vehicle, then you're going to need a warrant. Now we're going to turn to interrogation as we're starting to finish up. So after a suspect is taken into custody, it is routine to question them about the involvement in that crime, right? And this requires that police officers advise people who are both of these things, okay, and this is important, who are in custody and being interrogated. So custody and interrogation both have to be present. And if they are, the officer has to read that individual or advise that individual of their constitutional right from the Fifth Amendment not to incriminate themselves. And that is typically called the Miranda decision. And the case is Miranda versus Arizona. Okay? So, and suspects who are advised of their Miranda rights are basically told certain things. And here's actually my old Miranda card that I put up here. And it doesn't have to be exact, but you do need to give them, that individual, this information. So they have the right to remain silent. If they decide to make a statement, that statement can and will be used against them in a court of law. They have the right to have an attorney present at the time of the interrogation, or they will have an opportunity to consult with an attorney. And then finally, if they can't afford an attorney, one will be appointed by the court for them free of charge. And then, a lot of the cards and the Miranda cards will say, do you understand? And if you look at my old card, after everything that you say, you ask them. So you have the right to remain silent. Do you understand? Anything you say may be used against you in a court of law. Do you understand? You have the right to the presence of an attorney before and during any questioning. Do you understand? If you cannot afford to hire an attorney, one will be appointed for you free of charge before any questioning if you want. Do you understand? And this way you can ensure that they understand exactly what it is that you're talking about. Now, the Supreme Court has modified the Miranda rule to some extent over the years, and mostly its decisions have relaxed the rule. But the impact of Miranda on law enforcement, such as through lost convictions, etc., it really is fairly minimal. Okay, so there's not a lot of cases really that are lost as the result of kind of mess ups in Miranda, if you will. Okay, so that's a little bit about Miranda versus Arizona. Well, now what about booking? And talking about booking individuals. Well, let me kind of go back to Miranda on one more thing. I want to make sure we know what the public safety doctrine is. So the public safety doctrine is the principle that a suspect can be questioned in the field without a Miranda warning if that information the police seek is needed for public safety. So that could actually mean something simple like you're chasing somebody that has a firearm in their possession and you lose sight of them as they run around the corner of a building. And as you catch up to them, let's say you finally catch them and now they're not in possession of that firearm. So could they have thrown that firearm into a backyard where a child could obtain that? So that would be something that would fall probably under that public safety doctrine. Okay, so again, these are important things for us to know because there are a couple of exceptions as it relates to that. Okay, so again, booking, this is the administrative record of an arrest. This lists the offender's name, address, physical description, date of birth, employer, time of arrest, offense, name of arresting officer. And for these general type questions, it's not an interrogation, so you don't need to Mirandize someone just to get booking information. Remember, custody and interrogation relative to the crime, okay? Well, what about a lineup? Kind of pre-trial identification, if you will. So, after the accused is arrested, he or she is ordinarily brought to the police station where the police, list the possible criminal charges. And at the same time, they obtain other information, again, kind of like the booking thing, right? Now, in a lineup, a suspect is basically placed in a group for the purposes of being viewed and identified by a witness. And lineups are one of the primary means by which the police basically identify suspects. And one of the most difficult legal issues is really determining whether the identification procedure is suggestive and consequently a violation of due process regarding, let's say, the 5th and the 14th Amendments, right? So, again, lineups are the primary means that police have of identifying a person. Others are what they call show-ups, which occur after, or at the time a crime has occurred, kind of out at the crime scene. So that would be something that would happen at the scene out there, and you're going to do a field show-up. And then there's a photo lineup, which is basically a series of, photos or mugshots of possible suspects. Now, for photo lineups, those tend to be the most common these days. And for a photo lineup, the individuals are not, you don't have to give them the right to an attorney. So, again, a physical lineup is commonly used when the suspect is in custody and there were witnesses to the crime. And at its most basic level, a police lineup involves placing suspects among people not suspected of committing the crime. So and it's usually 6 to 10 people, and these lineups may be what they call sequential or standard. So, and again, it can't be suggestive, so people are supposed to be somewhat similar. They can't just stick out, right? Kind of like in the picture. So, without getting into too much detail, a simultaneous lineup is basically where all the suspects come out at the same time, one after another, they're all together. A sequential lineup is where the witness views one member at a time. And this, basically the simultaneous or sequential lineup is the same thing you could do with a photo lineup. Typically, a photo lineup is you look at all 6 pictures at the same time. A sequential photo lineup is you look at one picture at a time. And a lot of individuals think that the sequential lineups are a lot more fair. Okay, so that's kind of the difference between the two. And then they have what they call a blind and a double blind. And again, I'm not trying to get everybody all mixed up here, okay? But a blind is basically where the person that's giving the lineup doesn't know who the person is. And a double blind ensures that neither the witness or the police officer knows who the suspect is. So you might have somebody come in who's unrelated to the case to do the lineup. That way the person can't contest the lineup and say, well, the officer kind of nodded or showed, I think the officer pointed to me, so they gave it away. So again, here's a standard lineup versus a double blind, okay? Okay, so I know it's a lot of information to kind of swallow, a lot of things to kind of figure out when you're talking about all these different types of lineups, etc. Just remember that a lineup, again, I'll go back to kind of help you, is where a group of individuals are brought in and one person in there is the suspect. It happens live. They are entitled to an attorney at a live lineup. Okay? And these lineups can be sequential or standard. Standard is they all come in and stand there and they all have a number, etc. or they can be, sequential, which means one person comes in, you view that person, they leave, and then another person comes in. It can be the same way with a photo lineup. You're going to view all photos at the same time, or you're going to view just one photo. A photo lineup is where the person is not entitled to an attorney, because typically they're probably not in custody because you're trying to identify them. So you get 6 photos typically. Sometimes it's 8. It's usually 6 because they call it a 6-pack. And the witness will view the 6 photos and they will pick the person that they believe is the suspect. And then there's a field identification, which is where after a crime has occurred, law enforcement might detain somebody, let's say a block away, and they will pick up a witness or a victim and drive that person over to where that potential suspect is at, and they will identify that person in the field. So again, that's called a field show up. So a lot of different things, right? Again, a lot of content, a lot of stuff. So hopefully this kind of makes sense to you. All right, and then finally we're going to finish up with the exclusionary rule. So no review of the legal aspects of policing would be complete without a discussion on the exclusionary rule. And basically, to kind of cut through all of it, any evidence illegally seized by police will be considered tainted and thus inadmissible in court, regardless of how important or relevant it is to proving the suspect's guilt. It can be the smoking gun, it can be the bloody knife, it can be whatever it is. And if it was seized illegally, you're not going to be able to use it. Now, by extension, okay, any further evidence obtained from the initial illegal search or seizure will also be deemed inadmissible via a doctrine called fruit of the poisonous tree. So hopefully this kind of makes sense. So if you stop someone and you illegally search them, and in that search you recover evidence that leads you to, let's say, a drug stash house, and you find 1,000 pounds of cocaine at that stash house, that is also going to be inadmissible, right? So any evidence obtained as a result of the initial bad search is also deemed inadmissible. So you have the exclusionary rule, and then you have the fruit of the poisonous tree. So a couple of super important things for us to remember, because these doctrines are important because you can lose cases on this. So the exclusionary rule, the principle that prohibits using illegal obtained evidence at trial, fruit of the poisonous tree, secondary evidence obtained from a bad search first that violates the exclusionary rule is also deemed inadmissible. Now, with that said, quickly, 3 quick exceptions. One would be independent source, the rule that allows admission of evidence that has been discovered by means of an independent of any constitutional violation. So somebody else gives you the information. Good faith, the principle that evidence may be used in a criminal trial even though the search warrant used to obtain it was technically faulty, as long as the police acted in good faith when they sought the warrant from the judge. So this could be, maybe you describe the location and you mess up one of the numbers. So it's 128 North Willow and you put 126 North Willow. So the address is technically wrong, but it was a mistake. Okay, so little things like that. And then finally, what they call inevitable discovery holds that illegally obtained evidence may be admitted at trial if the prosecution can prove that the evidence would have been discovered inevitably. So we likely would have found it anyway. Okay, so a lot of content, a lot of things to cover. Again, we went over just a little bit, but that's okay because I think we got everything in there, and hopefully everything makes sense to all of you. But with that being said, this is going to conclude part 2 of Chapter 8, Police and the rule of law.